I'm Bill Kovacic. I'm a commissioner with the U.S. Federal Trade Commission, and it's my enormous pleasure today to interview Kai Ewing. I want to welcome you, Kai, to this series of interviews.
Thank you, Bill. I appreciate being here.
Kai, I'd like to start by thinking about the first great journey you made in your lifetime, from your home in Texas, your undergraduate years at Baylor University, to Cambridge, Massachusetts, where you went to law school. Tell us a bit about what that journey was for a young man leaving his undergraduate studies at Baylor.
Well, I was born down in the town of Victoria, Texas, and my parents lived in an even smaller village called Port Lavaca. And when I was about 4, I moved to Central Texas, to a big city. I mean, we had at least 60,000 people in Waco at that time. I went to the public schools there, went and attended Baylor University and got a BA degree with a major in economics and another one in history. And then I decided I really wanted to see the wide world, and I applied to a couple of law schools. And I only applied to a couple of law schools, namely Harvard and Yale. And as the year went by, I got a little concerned that I should have broadened my looking. But fortunately, Harvard came through, and I attended Harvard Law School and graduated in 1959.
What was the sensation like for the first time walking across the campus, and what must have seemed like a different world for you?
It was a very different world. I remember walking on my first day of class past Langdale Hall on my way to a torts class and thinking, I don't know anybody within 500 miles, and I have not the foggiest idea what a tort is. What am I doing here? But my teacher was the chief judge of the First Circuit, Calvert Magruder, and I soon learned what a tort was and enjoyed it, frankly.
Now, my guess is that, like so many of us who approach law school without having a keen idea of what antitrust was or whether to take an interest in the field, this probably was something new to you. Can you tell us what interested you about antitrust, and who in the classroom provided your first introduction to competition law?
Well, my introduction came from Donald Turner. I took his course in antitrust at Harvard. And I've said to many people the light bulbs went on in my head because I could combine law and my economics background from undergraduate school, and I really became interested in it. And it also seemed to me from Don's teaching that it was a subject in which you could continually look at new facts and new industries and get a knowledge of business out in the wide world. So I really became intrigued with antitrust at that time.
Are there any features about the way Don ran the class that stand out in your mind, about themes or topics that still run through your mind when you think about competition law?
Actually, yes, a couple of them. First, the district court opinion in Brown Shoe had come down, and Don in class would try to get us to think about the difficulty of every bit of evidence being relevant to a rule of reason case if you read that district court opinion in that particular way. So he was concerned about that. He was also concerned, if I remember, about concentration of industry. Those were the big themes, and what he conceived to be at the time as the merger wave. Those are the things I remember from the course.
You come to the end of your studies, and it's time to think about next steps. What were you thinking about as you came to the close of your law degree?
I guess getting a job, and I was fortunate to be hired by Covington and Burling. And I remember when I asked Mr. Burling when I should appear, telling him that my exams would be over in early June, I could immediately come down, and he asked me, well, have you ever been to Europe? And I said no. And he says, well, for goodness sakes, take 3 months and go to Europe first. You won't have another chance in many, many years. And that's what I did. So I reported for duty at Covington, I think it was in October.
Was the recruiting process then that people would come to the campus in the last year, or did you write them? How did you make the contact with them?
People came up to Harvard, to the campus, and interviewed. And I was interviewed by Graham Claytor, I remember very well. And fortunately, he decided to hire me.
I gather from that era, that must have been a remarkable time to be at Covington. I'm sure it still is a remarkable time to be at Covington. But when you arrived at the firm, tell us a bit about the people you worked with most closely?
Well, it was a fascinating time, and there were sort of two principal areas that I was put to work in. One was antitrust, and I worked directly for Paul Warnke doing FTC cases. Then I worked for Harry Schneiderman doing a cost justification study under the Robinson-Patman Act, working with Herbert Taggart, who's the only professor ever to write a treatise on cost justification under the Patman Act, and using the Sylvania block square computer in Camillus, New York, to do a cost justification study of 1,600 tube types. Now, the reason it was so large is that the computer didn't have microchips, it had vacuum tubes. It was an early version of a computer, but we managed it. And then I worked a bit for Tommy Austern on counseling matters, and I actually joined the ABA because Mr. Austern really ordered me to attend the spring meeting in 1960. I'll never forget it. But the second thing I did at Covington was in the international area, and I think there were two people in particular, John Lord O'Brien and John Leyland. Mr. O'Brien, interestingly, had been Herbert Hoover's antitrust chief between 1929 and 1932. He was also counsel to various governments and was representing Iran in a dispute with Iraq on the Shatt al-Arab, which is the confluence of the Tigris and Euphrates rivers. It was a border dispute, and I was put to work researching the border questions on that issue. And through Mr. O'Brien, I got into a whole bunch of international issues for mining companies in Peru and Chile and Mexico, and to some shipping issues with the Danish shipping companies, and finally into the Cuban expropriation cases, where I had a lot of interplay in New York and was a liaison counsel to equivalent cases in London, and had a really wonderful time doing all that. I wrote 3 briefs in the Supreme Court in the Sabatino case, which is the act of state doctrine.
Absolutely.
And then in London, I got to work with Sir Hartley Shawcross and Sir Elihu Louderpack, and Lord Spence, who is the last English Lord Chief Justice of India. It was heady stuff for a 20-year-old lawyer, particularly one from Texas.
What was the atmosphere of the firm like at the time? I think it's so much the case now that law firms are measured in the hundreds, if not thousands, of lawyers with dozens of offices. What was the nature of the mentoring, the nurturing that a young man in the office got in those days? Well,
there was a great deal of mentoring and a great deal of nurturing. I was lawyer number 85, and I can remember Mr. Burling Sr., who had founded the firm, declaring more than once in my presence that you could not control a firm with more than 100 lawyers. Something I think the world, I'm not sure we've proved that he's wrong, but maybe we have. Certainly there are larger firms now. But it was a very congenial place of extremely bright lawyers that it was a challenge.
And I'm struck at how in that period it's that many of the names you've mentioned already who are iconic figures in the development of the Washington practice, but the who's who of figures in the legal profession. Am I right that Dean Acheson was someone you worked with as well?
Dean Acheson was definitely there. My first complaints that I drafted for federal court, they weren't antitrust, but they were carefully vetted by Hugh Cox, who had been Thurman Arnold's deputy and later became the Assistant Attorney General in charge of the War Division in the Justice Department. He's one of the finest lawyers I ever knew. It was just a remarkable time with wonderful people. Mr. O'Brien was the first chairman of something called the Washington Institute of Foreign Affairs, and he had me draft the legal work to create that. The first president of that was Undersecretary of State Loy Henderson. The first vice president was the sitting CIA chief, Allen Dulles, yes. And there were only 100 of us admitted into the institute. And I was on the board for about 40 years, and I'm happy to say the institute's still going strong.
And am I right to recall that it was Mr. O'Brien who moved your admission to the Supreme Court?
That's correct. He at the time was the dean of the Supreme Court bar. and was so recognized by the Chief Justice, and I felt like I was really getting a special admission thanks to Mr. O'Brien.
After this remarkable opportunity to start in the presence of so many remarkable figures in the field of competition law, what were your next steps after Covington?
Well, I went into a smaller firm where I became a partner and stayed there for a number of years. Tried to do antitrust as well as other work. We represented, I did work for the government of Greece, the government of Peru on international law matters, American Airlines, and some other clients of that kind. And I found that most of my antitrust clients were going to larger firms. And so I was getting a little frustrated. It was fine on one end of the line, but not enough antitrust for me. And I was very, very happy when Judge Bell interviewed me at the White House, and then John invited me to be his deputy at
John Shenefield.
John Shenefield invited me to be his deputy at the division.
Tell us a little more about how you first took an interest in pursuing the possibility at the department.
I can't actually remember whether I applied or whether somebody else proposed me to Attorney General Bell. I just don't know. But I remember getting a request by telephone that I meet with him, and I asked where, and they said the White House, and that was very impressive to me. I was scheduled to be at a hearing in Montgomery County on a local matter, and I had that hearing postponed so I could meet with Attorney General Bell.
And again, this is in roughly the fall of 1977?
That's correct.
Tell us about the office that you joined when you came to the Antitrust Division.
John Shenefield was the Assistant Attorney General. I was very happy to become his deputy because I that way got to work with several people that I'd already had high opinions of. Joe Sims, Hugh Morrison, the career criminal deputy, were the two deputies, Bill Swope, Director of Operations, and George Hay, who was the Director of the Economic Policy Office. And then when I got there, I discovered that the appellate section under Barry Grossman was reporting to me, the evaluation section under Neil Roberts was reporting to me, the policy planning office was Joel Davidow was reporting to me, and the executive office was reporting to me, headed by Frank Battle and his deputy Ralph Justice. And I should add, those are not famous names in antitrust, but Frank Battle won the government-wide award as the best executive officer in the United States government. Quite an honor, and you can imagine that I really enjoyed working with those people.
I mean, my impression is, as someone who's always looked with great admiration at the Antitrust Division as an institution, is that in many ways that is sort of a golden era when you talk about that collection of people and the professionalism they brought to the operations of the division. That must have been a heady time.
It was.
To be part of the agency.
It really was. We were not only involved with trying to get good cases and handle appellate work, we handled also the appellate work for the Solicitor General's office from 7 regulatory agencies who were an interface between those agencies and the SG's office. So I got to work with a number of government agencies, and we were also at the same time involved in the huge effort at deregulation of airlines, trucking, you name it. And the Hill was constantly proposing deregulatory type efforts and some other efforts that we had to oppose. But it was really heady work. I mean, for example, Bill, on the Hill, I got to work with people like David Boies and Steve Breyer, Mr. Justice Breyer, who both of whom at one time were working for Ted Kennedy in the Judiciary Committee. And I got to meet and know people like Peter Rodino. I mean, it was just a wonderful time to be there.
And you were there for really some of the late stages of the process that brought Hart-Scott-Rodino and the implementing regulations into the mainstream of competition law.
That's correct. On my first day in office, John Shenefield turned and said, "You have the draft Hart-Scott-Rodino regulations, review them and get back to me." And I held them up for a while to give Neil Roberts a little bit more time to negotiate with Sandy Funder over at the FTC about them. And some clients have later said I should have held them up a lot longer, but anyway, I didn't. But, you know, you have to also remember Hart-Scott was not only a merger regulation situation, but it also, that act provided that the Justice Department should give millions of dollars to the states for them to improve their own laws. And one of the quiet things I'm proud of is that we did manage to disperse that money and never had an accusation of any kind of wrongdoing either against the department or against any state that received the money. And I think they basically used it to modernize state laws, bringing them into line with the federal law, and thus avoided to some extent what Bill Baxter worried about, which was the balkanization of antitrust rules.
Now, you spent a lot of time, as you mentioned, in that period on what we might call congressional relations, the
Yes.
Large number of initiatives like Hart-Scott, the enormous interest in deregulation. Any really striking memories that stand out from your time going up to Capitol Hill, either advising on legislation or perhaps even being part of the process by which bills were marked up?
Well, I remember one of my earliest trips to the Judiciary Committee, which at that point was still chaired by Jim Eastland. And the administration had some interest in the bill. I may have even testified. I can't remember about that. But anyway, I was in the audience in the front row, and Chairman Eastland had to rule that when he finished the hearing, he would move to a small room next door and mark it up. Now, the small room had only enough chairs for the senators, and their aides had to stand behind the chairs. There's no outsiders allowed. Well, the senator was an old friend of my family, and so he motioned for me to come. He put his arm around me and led me into the little markup room. I was the only outsider in the room. When they finished the markup, we went out a hall door, and there stood Patricia Wall and two of her deputies. She was the Assistant Attorney General for Legislative Affairs. They were demanding to know how in the world I got into that hearing room. Well, I'm telling you, it didn't hurt my reputation at all, and I had the fun of many times going up with Pat Wall to the Hill to present issues for the division, the administration, and I enjoyed it.
If you look at the whole collection of legislative matters that you had a chance to work on as an advisor, consulting on behalf of the division, giving comments, are there a couple of items that stand out that you feel particularly good about having had a chance to work on during that time?
I think there's one that might surprise you. There was legislation against the oil companies that was being pushed by various senators, and the administration was opposed to this particular kind of legislation, as was the division. But it was a delicate political balance at that point, and I remember the general counsel of the Energy Department and I jointly went up to see people like Mac Mathias of Maryland and Senator Metzenbaum and others, and we quietly worked out a deal whereby the vote would be very close, but the administration's position would prevail. I'm very happy about that.
Yes, sometimes good results consist of sometimes blocking kicks.
That's right.
Sometimes scoring touchdowns. Certainly one other major initiative in this era involved something that John Shenefield helped set in motion, and I'm thinking about the National Commission to Review Antitrust Laws and Procedures. And I suspect, given the policy responsibilities that were part of your portfolio, that wide-ranging effort became a matter of your own attention.
Well, it received my attention, although there was a different group of people that John appointed to really interface with him and the other commissioners. But necessarily, because the commission included Senator Thurmond and Senator Hatch and others, my section's evaluation of appellate would have, and policy planning, would have input to it. So I wasn't so much directly involved, but indirectly, yes. It was an interesting time to watch that whole process unfold and to have our people come back into my office at night and say, well, this happened or that happened, and how do we answer that, and what do we do next, and this kind of thing.
In addition to a variety of non-litigation policy-related matters, this, of course, was an important time for the development of the division's litigation program, including the close of the decade in which the offense of price fixing had been now made subject to prosecution as a felony, an extraordinarily important takeoff in the modern era of the division's enforcement efforts. It's also, I suppose, in a modern era where we take leniency and amnesty for granted, it's also a starting point for the division's leniency efforts. How did that get underway?
Well, in something, I believe it was October of 1978, John Schinefield finally finalized his idea of granting leniency to corporations that would come in and confess and promise to tell everything. And he got the Attorney General's permission to do that. And John announced the leniency program, and I actually got the first phone call that came in seeking leniency, and within hours all the other deputies and the director of operation, I think John too, had gotten telephone calls about the same matter. And we sorted it all out and returned calls in a particular order. But it was a big deal, and we thought for a time it was really going to make a difference. Now, I think over the years we realized that, and others have realized, that it didn't go far enough. It didn't give enough assurance to bring in enough people. And that's where I think the Gary Spratling, Joel Klein effort in, I believe it was 93, to expand that program has proved so successful and been replicated around the world. I think it's a very important tool.
Was there apprehension at the time about the notion that people would get dispensations, wrongdoers in some ways would be rewarded for coming in and snitching?
That's exactly what was the tension there. How could you possibly, as a matter of prosecutorial discretion, simply give leniency, saying a bye to somebody who had committed a felony?
And certainly in the same era, you see the development of what's become widely accepted modern practice in the United States of subjecting individuals to serious criminal punishments. But that didn't start simply from nowhere. And this again is the decade when the division's involved in establishing that as a routine element of prosecution. Can you tell us something about what it was like to begin the routine process of seeking indictments of individuals, prison terms?
I'm not certain that I can really answer that question as to what it was like. From my perspective, I came to the division thinking that the most important deterrent you could have was to send individuals to jail. And I know that was shared by Hugh Morrison, the deputy in charge of criminal matters, and by Joe Sims. And I know John Schinefield felt that way. So I think it was a matter of finally having the tools to do it, and the staffs coming up with cases where you could actually put it in practice. One of my proudest accomplishments was occasionally they let me be the acting assistant attorney general, and I remember one time overruling the director of operations, Bill Swope, and indicting a whole bunch of people that he had said let's not indict. Well, we not only indicted them, but we convicted all of them and sent them to prison, which I'm very proud of.
Another litigation possibility in this time to step from the criminal enforcement side of the spectrum of cases back to the civil enforcement world was how to deal with the problem of concentration. Either individual firms or firms in what at the time were considered to be tight oligopolies, a handful of firms accounting for most production in an industry. Certainly one initiative that gained a lot of attention at the time for those of us who were just beginning our careers in the field was the concern with shared monopoly. And John Schinefield, in his role as Assistant Attorney General, was in the middle of a number of important policy debates about that. What role did the concern with shared monopoly play in the allocation of the division's resources?
John put a lot of resources into the effort by insisting that the staffs come up with a case. Some of us I think the other deputies and Bill Swope, the director of operations, and I were always concerned that John would go slightly beyond the text of a speech and say he was going to bring a case in a particular time frame, because some of us knew that the staffs weren't coming up with those cases. And I do remember graphically when John came into my office one morning and said, you know, you've got to do something with the staffs. We've got to produce a shared monopoly case. And he pointed to me and he said, you've got to do it. So my first thought was I should call George Hay, which I did. And George came up with, he was the director of the Economic Policy Office and had put together some 50 PhD economists in this marvelous office. And George and his fellow economists came up with the idea of a systematic look at underperforming industries. And George would, I think, say that there's a bit of a semantic problem as to whether we were looking for facilitating devices or whether we were looking for pure market structure. And my own concept was that John Schinefield would have taken either kind of case
yes.
At the time. Nevertheless, I don't think we actually brought a single case that was labeled shared monopoly. And when John became the Deputy Attorney General and had a successor in Sandy Litvak, that program was basically shut down.
Do you recall that the effort even got close to the formulation of a recommendation that here's one that might look good?
Not to my knowledge. Now, others may disagree with me on that, but I don't think I ever saw anything that I would have recommended to John that we go ahead with.
In addition to the shared monopoly, concern about concentrated sectors, there were celebrated cases involving individual dominant firms. IBM, AT&T being some of the most important. These certainly, in different degrees, came across your desk during that time. If we think about IBM, AT&T, any recollections about what it was like to have these sprawling, significant matters before you?
Yes, both IBM and AT&T had been brought prior to John Schinefield taking over, and certainly prior to my arrival. John did ask me when I first came to go up to New York and generally review with the IBM staff what the case was like. And I went up to New York. I was met with great suspicion because I was a so-called policy legislative deputy, and they were fearful of political interference. I tried to calm them on that score, but then I asked them about their document retrieval system. And I was introduced to her. She was a very nice white-haired lady that day wearing tennis shoes. And they said, this is our human document retrieval system. And I can tell you, Bill, when I went home, that was my first inkling that there was something seriously wrong with our IBM case. I didn't know whether we would ever win it.
I gather it wasn't the only sign that the overall disposition and conduct of the case was a headache. There were surprises for you as well when you got to see what was happening in the Southern District of New York.
Oh, yes, that's absolutely true. Because of the executive office came through me, I had to approve the expenditures before I sent them on to John Schinefield of the expenses of the IBM case, and I looked down one morning early on and found that we were paying in over a year several $100,000 in fees to have somebody sit in a darkened courtroom and read evidence into the record.
What a wonderful experience.
Yeah, I said, this is ridiculous. I just
Way off Broadway.
Way off Broadway, and I asked Joe Widmore, who was heading it up then, if he could do something about it, and he said, look, Judge Edelstein has ordered it. And I said, well, Joe, I'm not going to sign this thing until you go up there and ask Judge Edelstein to change his ruling. And he got David Boies to go with him. And in fact, Judge Edelstein did change the ruling, and we saved a lot of money. But that was another indication of some problem with the IBM case.
Did the experience of working on the case, did you sense within the division that here was a matter that had been filed on the last day of Lyndon Johnson's presidency in 1969? We're moving through the decade of the 70s and creeping up on the decade of the 80s, and it's slogging through this process in the district court. Did that become a source of burden to the morale, to the to the spirit of the division to have this long-running matter proceeding in this way?
I'm not certain that the overall division's morale went down because of it, because the IBM staff was in New York. It was sort of separated out, but it was clearly a worrisome thing. It was worrisome because IBM was taking appeals to the Second Circuit, and I remember going up with Barry Grossman and others to one of those arguments, and the presiding judge of the Second Circuit asked all the people in the audience who were with the Justice Department to stand up. Yes. And there were about 30 of us. And I was desperately afraid that the next question would be, who is the ranking officer, which would be me. Yeah. And I did not want that. They did not
account
ask
for
that
yourself.
question. That's
yes.
right. They didn't ask that question. But after you go through a number of these, you realize at the level of the front office of the division that you've got a real problem on your hands.
No doubt.
But nevertheless, none of us were willing to say, let's just shut it down right now.
And certainly IBM was the case, along with AT&T, that in their own ways had important intellectual property questions folded in. These were certainly, IBM was seen as a jewel of American technological progress. And this is a period in which fears start to be voiced that the U.S. does not have it right when it comes to the application of competition law in the fields dealing with intellectual property and innovation. And in a variety of settings, this is a set of issues that came your way too, because the division at different times had staked out what I suppose were increasingly being criticized as being particularly skeptical views about the acquisition, use, and exploitation of IP rights.
That's absolutely true, and my own involvement with the AT&T case was mainly in connection with Bell Labs, and I spent many hours listening to really quite intelligent people argue that it took some of the monopoly profits of AT&T in order to support the basic research done by Bell Labs, and that we shouldn't be impeding innovation by what became known as the 9 no-nos of patent licensing. And just to follow up a little bit, Roger Anderwelt, who was in the patent section of the division, came to me one day with quite a good study trying to show that the 9 no-nos basically didn't make any economic sense. And he and I devised a scheme to go to John Shenefield and others in the department and get permission for me to make a speech out in San Francisco to the Patent Lawyers Association, getting rid of some of the 9 no-nos and questioning some others, just starting down the process of changing it. And I can't resist this, Bill. I've only had 2 standing ovations in my life. One of them was by the San Francisco Patent Lawyers Association when I got rid of some of the 9 no-nos. Now, Roger became a deputy later, and Tad Lipsky, Bill Baxter's deputy, and the 2 of them got together and abolished the 9 no-nos and put in place a more rational, economics-based interface, which I think has helped us, but I still think we are not all the way there in understanding how patents and innovation work in a competitive society, and the complexity of standards now, some of which involve thousands of patents, any one of which could block the introduction of the technology, is something we really still haven't come fully to grips with, in my judgment.
And this is something that I wanted to dwell on maybe a little bit later, but it seems a good moment to raise it. A criticism that's made of antitrust enforcement, the development of competition law and policy in public institutions, is that many of the relevant industry developments are unfolding at a pace that the public institutions simply can't keep up with. They either can't learn enough to accurately diagnose the phenomena they're observing, or when they make an accurate diagnosis and they want to intervene, they're not very good at picking the right instrument to do something about it. Do you have reflections on your time, especially in this crucial decade in the 1970s and coming forward, about how serious a problem that is for the policymaker, even for yourself during this period, and what do we do about that?
Well, I would start with mentioning where we were in the late 1970s. The White House office dealing with research and development, science, the Office of Science and Technology, became quite concerned that institutions were getting very, very scared of antitrust problems and not doing as much innovative research as they should be. And they asked us to produce a guide on research and development joint ventures. And that's where I first decided that maybe the agencies needed to do a little bit more, because the first drafts I got from different parts of the division showed very, very different approaches to the analysis of a research and development joint venture. I think we finally got the division on board on one type of analysis, which I think is still basically present. But it led me, at the request of the White House Office of Science and Technology, to make a lot of speeches up at MIT and places like that. And I realized that in the wide world there was a lack of knowledge of antitrust, just like perhaps in the antitrust agencies there was a bit of lack of knowledge about what the organizations were doing, standards organizations and so on, and that we needed to talk more. I think that we've progressed a great deal since then. And I don't have any magic solutions. I was involved with the, just before I ceased to practice with Vinson and Elkins, I was involved with the patent platform for the third generation of mobile telephony, a very complicated issue. It wasn't a patent pool, it was something else designed to try to get innovative patents actually in use in a way that kept people from blocking the whole thing. We need to explore further developments of that type. I'm not saying that is the end-all model, but we need to think about new ways of doing it.
One of the complaints in this period dealing with cases that we mentioned, such as IBM, is that in the time it was taking to try the case, to present evidence, the industry continued to evolve. And how could the traditional big case possibly cope with unfolding phenomena of this kind? Do you think we learned something from the experience of trying the big case in the 1970s?
I think we learned a great deal about what not to do, and then I think more recently the agencies and everybody have learned to use the modern techniques, electronic techniques of all kinds. You've got briefs being filed at the Court of Appeals where the judges can press a button and get the underlying facts that you're trying to cite in a record. This kind of thing I think will help. In a certain sense, I feel like it's almost passed me by. I'm not as up to date on it as I should be because I think it's progressing, and I think the agencies are progressing with it.
In this remarkable decade of transitions, not only do we have the big case, the big statutes, the big innovations in enforcement practice, such as amnesty, leniency, but it's also the point in many ways to go back to your early experience as a lawyer working on international matters, that U.S. antitrust law is bumping with increasing frequency into matters involving other jurisdictions. And I'd like to take you through, if I could, a couple of those episodes. Certainly one that you became familiar with was something called the uranium cartel case.
Oh, yes.
What was it like to work on this one?
I was involved only with the civil cases that were filed not by the division but by private parties. It all started when the Friends of the Earth sent to Joel Davidow's home in Virginia a box of documents containing the minutes of the uranium cartel. Joel immediately, as then head of the Foreign Commerce Section, brought an indictment. The main company pled guilty, and the next day after the indictment was filed, they had a consent decree, and the government's part was over. But then the civil suit started. And that's where I got involved because Canada, the United Kingdom, Australia, you name it, complained about the United States exercising extraterritorial jurisdiction. And my dear friend John Chenefield would send me over to the State Department to sit there while the representatives of Canada or the UK or whatever would rail at me about this terrible, terrible abuse of power. And I always became good friends of a number of these people. And I always found it ironic that it turned out that the only government that ever put anybody in prison for the uranium cartel was the Canadian government, and they had squawked the loudest.
This is always the period, also the period of growing involvement in international organizations that were taking an increased interest in competition law. The OECD, the United Nations, these were venues in which you spent some of your time also.
Yes, John was willing to let me lead the U.S. delegation to the OECD Committee of Experts on Restrictive Business Practices, now the Competition Committee, and had a great deal of fun over there. There was a small committee at that point. There weren't too many people that had real competition policies, and the Germans did. Kurt Stockmann became a good friend. He would represent the Bundeskartellamt. And the British were still sending people to the OECD to complain about our extraterritorial jurisdiction. I remember one time when Kurt and I decided we would conspire a little bit with some others, and we forced the UK representative to admit that his new clawback statute was itself an exercise of extraterritorial jurisdiction, because they were doing in the UK, having put their claws on things in the UK, concerning things located or done previously in the United States. And so it was a clawback kind of situation. We had a lot of fun there. And of course, the efforts at the UN that Joel Davidow was representing us on were important and took a considerable amount of time, because basically not too many people in the division were too concerned about what was happening, elsewhere in the United Nations. They wanted to bring cases.
You must have had a few moments in these international discussions that provided unexpected turns and twists. Care to share one or two episodes that stand out, that aren't necessarily the formal mainstream of competition law, but show something about what it's like to be involved in these different organizations?
Well, I'll share one. Joel Davidow, who had long been head of the Foreign Commerce section and was under Schinefield head of the Policy Planning Office, but continued with his international obligations, was really one of the chief negotiators in both the UN's effort for a code of restrictive business practices and the UN's effort at a code of transfer of technology. And in those negotiations, there was the United States and a Western bloc, and there was the Soviet Union and an Eastern bloc. And in one of these, I guess I should tell the story this way. I got a call one morning. My secretary came in and said, "You have a call from one of the most irate government officials I have ever heard." And I said, "Well, who is it?" She said, "It is the Assistant Secretary of State for European Affairs." And in those days, that was a real powerful office in the State Department. I think it still is. Well, he came on and he said, "Do you have a Mr. Joel Davidow working for you?" "Yes, I do." "Do you know where he is?" "Yes, he's in Geneva negotiating a treaty." "Well, you have him recalled because he has just reached an agreement with the Soviet Union, and only the President of the United States can do that." And they were really upset. Turned out, when I reached Joel, that what had happened was he had made some proposal, and the brand new Soviet delegate had murmured words that seemed to be an acceptance, and the chairman, thinking some breakthrough had occurred, had banged the gavel and called for lunch. The State Department representative had called the State Department saying, "We've reached agreement with the Soviets," and it got up to the Secretary's office. So I was by the time I called him back and said, the Soviet representative came back in after lunch, withdrew his agreement, there's no problem. Joel was totally unfazed, but I had to spend the afternoon getting the Assistant Secretary of State for European Affairs calmed down.
This is also a period of fairly extraordinary work in the field of petroleum. This is where the question of OPEC's ascent becomes increasingly important, dealing with a variety of matters associated with price increases assume a great deal of attention. You had some dealings on questions of petroleum supplies. What was that like?
Well, I had a number of different experiences. When the lawsuits against OPEC started, people came into Doug Rosenthal, who then was head of the Foreign Commerce section, and some to me, arguing that the government should either get involved in supporting the lawsuits or keep out or oppose the lawsuits. And Doug and I took the position that the courts could deal with it on their own. We had the active state doctrine, a la the Sabatino case in the Supreme Court. And I think the government was wise to keep out of those cases. But the overall energy crisis presented a lot of funny situations. I remember at one point the Defense Department was having trouble getting the oil companies to bid on supplying the fleet with fuel. And so they called a meeting that was held at the Pentagon. It was the Secretary of Defense, Secretary of Energy, and possibly the Secretary of the Treasury. I'm not sure about that. Anyhow, they asked all the CEOs of the oil companies to come down. And they agreed, but only on the condition that the Justice Department send a hostage. Well, I was the hostage, and I took Don Kaplan, who was head of the energy section, with me. We went to this meeting. There was the Secretary of Defense, Secretary of Energy, the Chairman of the Joint Chiefs, all the Joint Chiefs, the civilian secretaries. It was an impressive gathering. And the Marine General made a very patriotic, fervent speech asking for help in getting bids to supply the fleet with oil. And Leon Hess, who was head of Amerada Hess, rose to the occasion and made an equally patriotic and fervent speech suggesting that he would start bidding immediately, and he asked all his fellow CEOs to bid on the same terms that he had proposed. Well, Don Kaplan kicked me under the table and said, "I think you better intervene." And in a very loud voice, I did. I said, "I hope you'll all do it independently and privately and avoid any violation of the antitrust laws." Well, chaos ensued in that room until Graham Claytor, who had hired me for Covington, he was Deputy Secretary of Defense, in an equally loud voice said, "I think Kai is absolutely right. You know, do it separately. Don't chance an antitrust violation." And Mr. Hess came up to me later at the end of the program, still mad as hops, that I had been unpatriotic in keeping him from achieving his goal. And fellow CEOs pulled him away, and I guess we ended friends. But it was sort of a funny experience.
How about the Phantom ships off the coast of the United States?
If you remember back in those days, the newspapers started talking about the fact that they considered that the oil companies were holding off the supply of oil in ships that were off the coast of California. And somebody at the White House got the idea that at least we should counter by investigating. And the Coast Guard was ordered, and I was under instructions to contact the Coast Guard and to quietly go out to San Francisco and see our San Francisco field office. Well, the Deputy Commandant of the Coast Guard lived right across the street from me, Admiral Henry Bell, so I called Henry that night and said, "You know, we've been ordered to go do this." Henry thought it was a foolish thing because they already knew there weren't any Phantom ships, but he nevertheless sent out search parties, and I nevertheless went out to San Francisco. And when we got there, somebody leaked to the press the fact that a Justice Department official was investigating the Phantom ships and was in the building. And the chief of the office snuck me down the back stairs to avoid the press because I'd been told to do all this quietly.
You come to the end of 4 remarkable years, roughly, at the division, and it's time to move on to something else. And the something else becomes over 2 decades at Vinson & Elkins. If you had to single out an episode or so that stands out from your time going in to private practice, from what I gather was about as much fun as you'd ever had before.
Oh, yes.
What experience stands out in your mind from Vinson & Elkins?
I think I should say that it was the experience of working with some other great antitrust lawyers, Harry Reasoner, Charles Newton, Alan Van Fleet, and a number of others. It was just a wonderful place. And at the division, it had been so much fun to work because you could talk to other people that were intensely interested in antitrust. And I found that true at Vinson & Elkins when I joined it. And those were wonderful, wonderful days. Cases I had...
pick one pick one from the list.
I had really, I don't know, probably thousands of cases, but one I enjoyed a lot was a client I enjoyed a lot was representing Halliburton. I represented them through, I think, 3 or 4 CEOs, the last CEO being Dick Cheney. And we did a series of mergers for them. And when Halliburton decided to merge with Dresser Industries, we were asked to do an exhaustive antitrust analysis. And I said, well, now, if we do it, we're going to have to present it as a 4C document in a Hart-Scott. They said, okay, go ahead, just do it the right way. And so we prepared a huge volume, really analyzing in the way I would have done it at the division, what was involved, and taking possible markets, not only the ones we thought, but the ones we thought other people might consider to be markets, and analyze them. And it actually suggested in the paper certain places where divestitures might be called for. And we did present it to the board of directors of Halliburton, thus it became a 4C document, and it became the Bible, and it became the Bible of the Antitrust Division, of the European Commission, of the various other governments we had to go through to get that merger through, and we finally got it all through. I think the most interesting time was at the EC when the staff over there absolutely demanded that they be allowed to land on a North Sea oil rig. Now, Halliburton doesn't own oil rigs. You have to go to an oil company to do that. And it's very hard to get permission, but we got permission for...
These aren't routine tourist attractions.
Yes,
no.
Well, not a routine tourist attraction. The commission people had to undergo training, wear rubber suits and so forth in the helicopters that took them there. But they were very happy with it, and I think at least it demonstrated that we were trying our best to give them all the evidence we could. And I always think of that case as one where many CEOs would have said, no, we're going to hide this. We're going to make the government, pull it out of us. Instead, we went and openly presented what we knew, and it worked.
This is the period, your time at Vincent Elkins, in which you became a very active member of the antitrust section, and it's a chain of activities that lead in 2000, 2001 to your time in the elite group who served as chair of that body. I wonder, as we come to the close of this discussion, if you can talk a bit about which experiences from that time stand out in your mind as being the contributions that you're happiest about.
Well, I set out with the idea of doing 2 things. One was to have the section do some studies of the theoretical bases of antitrust, and I created task forces on fundamental theory, on time, change, and materiality, and antitrust and litigation that were chaired by former chairs of the section, and I think did some good work, and they produced some published reports. The other thing I wanted to do was to put more firmly into the section the international world, and I'm proud to say that I achieved something there. Mario Monti was the first EC commissioner ever to appear at our spring meeting. Alex Schaub was the first director of the competition directorate to appear. And I remember sitting at the spring dinner with them, and they talking across me. Each was surprised that this huge 1,200 body group existed. They had thought Fordham, with a very much narrower clientele, was it. And sitting there with me, they vowed they'd continue to come back. And I'm pleased to see the Commissioner, Nita Cruz, is here this time, and they've consistently been here since 2000. I think we really did get the international world started. I called friends around the world that I'd gotten in the OECD days at the division, and a number of them showed up in 2000, and I think that's mushroomed. I understand today, under your wife Kathy's leadership as chair, there are 48 countries represented here. I think that's remarkable.
That's an extraordinary legacy that does carry on. And in your own work, you've now got a book, Competition Rules for the 21st Century. You've had a lot of time now to think about the way ahead. And I wonder if you could close us out today with a minute on if you had to pick something we've got to focus on and work on in this community, what would it be?
I'm almost tempted to say there are two things.
You can take two.
One is to make merger enforcement more efficient. I think it's a very inefficient system to have upwards of 10,000 filings a year to get 6 to 10 cases. We've got to do something there, and I think we can. If we look at the data and look at the empirical data, we can make some changes. Probably the two agencies can make the changes to achieve more efficiency there. The second thing is I think we and the rest of the world have to come to grips with the issue of the dominant position and the use of market share to say if you have a particular market share, you're so big that you are prohibited from doing things your rivals can do. I think that's a bad way to go about competition policy, yet that is the way much of the world is going about it, somewhat aided by the way we go about it. And I think we need to rethink that. I know Randy Treitel and the ICN is focusing on that. I hope they can succeed in persuading people to take another look at it. I'm very concerned about the EC's apparent divergence from the U.S. view in the area of what they call joint dominance. It smacks a little bit to me of that old shared monopoly, and I'm scared about it. If they're only doing facilitating devices, maybe that's something else again, but I'm not sure that's the way they're going. So I think if we could get merger enforcement made much more efficient, and if we could deal with the issues of unilateral conduct in a better manner, I think we would be better off. And Bill, let me tell you, I am a great believer in what you have advocated, which is a constant reevaluation based on data. Get the data out to the world from the agencies and from the courts everywhere, and then analyze it and act on the reevaluation to make it better.
As one of my former FTC colleagues David Hyman puts it, in God we trust, all others provide data.
Right, exactly.
And Kai, I want to thank you for giving us an hour of what, to those of us who've watched your work over the years, has truly been a great life in the law of competition policy. And thank you for sharing this wonderful journey of experiences with us, Kai.
Well, thank you for having me. I consider that I've had a wonderfully fun life, and I've had fun today. Thank you.
Thank you, Kai.